Hi, my name is Stephanie Freeman. I'm an attorney who specializes in the area of trusts and estates. That means that I write people's wills, powers of attorney, assist them in getting guardianship or conservatorship. I do probate administration, which means after someone dies, going to court with the family and taking care of their loved ones' affairs. I do a lot of client counseling, and answer questions that people might have about their existing estate plans or when they're possibly contemplating creating one for themselves.
Great. So we can start by kind of talking about last wishes and end of life planning. Um, what would you say like is the basis? What is end of life planning and why is it important for families to start early?
So, what is end of life planning? End of life is planning is what happens to you before you pass away, but you're in a situation where you're not well. You'd like to make your wishes known. Maybe you are well, but you'd still like to make your wishes known if you are in that situation regarding what happens if you're in a terminal condition, what happens if you're in a persistent vegetative state. People can make those decisions before that situation arises and put it in writing. It's good to do this early, as in today, because it's always best to proceed from a position of strength. If your family knows, or the person of your choice who's going to be making these decisions for you in the event you can't, if they know what your wishes are, that makes life easier on everyone, both yourself and the ones you love around them. Some decisions that you might contemplate are, do you have a DNR? That's something called a do not resuscitate in the event of that sort of set of circumstances. It also refers to if you are in a coma or unconscious or not well in a hospital, do you want feeding? Do you want nutrition? Do you want artificial nutrition? Do you want hydration? Do you only want pain relief? These are the types of decisions that come into play at end of life. And end of life planning puts it down in writing in a formal document. And you've selected who's going to make those decisions for you in that writing in the event you can't.
Yeah, definitely. Um, and then what would you say are some common like myths or misconceptions about end of life planning? Like I know a lot of people put it off or they're kind of scared to like take that jump. Could you elaborate a little bit on that?
Sure. So, you know, there's a joke. Oh, if you, well, it's not really a joke, it's true. We're not going to get pregnant by talking about sex. We're not going to die by talking about end of life. Um, these are natural processes. Death, unfortunately, will happen to all of us one day, hopefully not for a long time. But there is a lot of fear about it. No one really wants to think about it. No one really wants to talk about it. But they do get peace of mind when they do and take care of this important business from a position of strength. Some people think, oh, I'm so young. I don't need to do this for a long time. Hopefully, that is the case. Sometimes it's not. So, overcoming that sort of resistance or reluctance, in some cultures, it's taboo to talk about these types of events. People feel like they're, putting a negative energy on themselves. Maybe it's not in line with their religion. Those are some reasons why there are hurdles for, some folks to not really want to address it or feel that they can't. But if you can overcome that sort of resistance, it is only a benefit to you. And most importantly, in addition to yourself, to the people who are at your bedside in the event you ever are in such a situation.
Mm-hmm. And there's a lot of parts that go into that, obviously, like wills and advanced directives and trusts and stuff like that. How do you think that technology has uh, made this more accessible, easier? Like, helped people for planning these types of things?
That's a good question. Trust in the states, some people feel is like kind of a dusty area of law. It's pretty, predictable. Wills are what happens to our property after we die. That's what a will is. It doesn't come into play until after we're deceased. Powers of attorney, um, those are designations of who's your village, while you're still alive, but out of commission, whether you're disabled or incapacitated for some reason, or maybe you're out of town on a long vacation. There's reasons why people want to have an agent. I think technology has benefited because it's made it so much easier to share our documents with our friends and family, no matter where they are. That way, there's no surprise if there's, an unfortunate event, whether an accident or unfortunately a death, that the people who are in line to take care of your business for you in the event you can't due to disability or incapacity or death. It's a really neat way to make sure that they've got it, and in the palm of their hand, they can pull up those documents immediately.
Hmm. Whether it's like an emergency or you're just like getting all of your stuff in order and you want to be prepared.
Exactly. It is a form of preparation.
Mhm. Okay, well, we're gonna pivot a little bit and then start talking about power of attorney and kind of explain that a little bit more. What are some examples of decisions a power of attorney might make for someone on someone's behalf?
So it's really up to the individual who's giving agency to someone to serve as their agent under their power of attorney. The person whose power of attorney it is called a principal. The people who they designate to take care of their business in the event they can't, those are called agents.
Mhm.
Um, so one can have a power of attorney for your financial affairs, where you select people who will make your business decisions to the extent or as limited as you desire. It's totally in your control. The powers of attorney that I prepare for my clientele are generally very broad, and they allow an agent under a financial power to basically, become the principal in the event the principal can't act. Certainly, there's limited powers of attorney. Sometimes you just want to give someone permission to, go to your safety deposit box in a different city because you're elsewhere. There's ways to craft those documents that are very specific and they expire in a certain amount of time. It's really up to you. They're your documents. Any attorney working with you will be able to explain that and get to the root of what your desires are in this regard. For medical powers of attorney, again, they can be as broad or as limited. Generally, in the medical powers of attorney that I prepare for my clientele, they give the agent broad decision making over your person. The financial power of attorney is over your stuff, your
Mhm.
business, your work, your bills, um, that sort of that area of your life. But a medical power of attorney is really over you. If you need care placement, if those advanced directives, what happens at the end of life? The living will and advanced directives are incorporated into the medical power, assuming that's what the principal wants. Like I said, it's extremely customizable. You don't have to do anything, you don't have to have any powers. But if you don't, there can be trouble in the event of your disability, incapacity, or death for the ones around you as well as yourself.
So one person like you can do all of it, like the medical, financial, everything. Okay, good to know. I feel like I didn't know that.
Yes, that's part of an estate plan generally.
Yep.
Um, what is going to happen to us while we're alive at our bedside,
Hmm.
and what is going to happen to our assets, our physical legacy after our death. An estate plan generally also will have documents that relate to plans that we made for the disposition of our body after we transition to death. So some people choose to be buried, some people choose cremation. There's, a number of avenues to discuss. Some people, make very extensive pre-plans. They buy a cremation plan while they're still alive. So
Mm-hmm.
they've locked into that. It's taken care of. There's no burden on the loved ones after death. Some people just, maybe financially it's not in the cards to do that, or they just, put it off and leave it, or maybe they think they're, in a family plot. There's so many different avenues. There's green burial, water cremation.
Yep.
What happens to our remains? Happens at our funeral or memorial service? Those decisions are also memorialized in an estate plan. Further embodied in an estate plan where it's relevant to the client is what happens if there's no parents still living and there's children under the age of 18.
Mm-hmm.
So in my practice, I prepare a nomination of guardian. So that's who do you choose while you're alive and both parents are not able to care for their child. Who do you choose to do that? And then your will be crafted um, in line with that nomination for who might be a trustee under your will, for any trust created for your minor children, for your assets, for your money. How is the child's care going to be funded if you do have assets? Who will serve in those roles?
And what if you do not have a power of attorney aligned and then you um, pass away or I don't know how you put it, the went to incapacity?
Sure. So powers of attorney, like we said, are only while we're alive.
Mm-hmm.
Once we pass away, they are extinguished, they're gone. That's when your will comes into play, disposing of your property.
Yep.
But while you're alive, that's power of attorney land.
Okay.
Um, so your question is, how does it trigger? Some powers are specific. They say only if two doctors say that I'm unable to make decisions, is this coming into play? And then your agent, the person that you've chosen to make those decisions, that's when they start, getting busy and doing business on your behalf.
Yeah.
Um, but they are only while we're alive.
Okay.
So
Got it.
sometimes we choose different people as our agents. Like some people, if one person that you might choose is really good with financial matters, very organized, not uncomfortable, taking care of like business kind of related matters, that's a great choice to serve as your financial agent. However, they may be very uncomfortable with health decisions. They don't communicate well, in the healthcare setting. They're afraid. They might not be the best choice to be your agent under your medical power. You might choose someone else.
Mm-hmm. And what advice would you have for any like caregivers that are acting as power of attorney for someone? Maybe if like they haven't done this before, it's overwhelming, I'm sure.
Sure. Client education is really important. And I think also, what I didn't answer before is what happens if there is no power of attorney, there's no agent,
Yeah.
and the principal has never set down in writing their wishes as to who's going to make those decisions for them in the event they're disabled or incapacitated and they can't.
Mm-hmm.
When decisions need to be made for that person, this is when having an estate plan really shines, because it's already in writing, it's already decided. What's a very bad time, because it's not a good time when someone you care about or are working with is out of commission.
Mm-hmm.
And having the documents in place, that's taken one big burden out of the mix, because we know who's in charge. We know they have the power to do the things that need to be done. When there is no power in place, that's when people have to go to court and ask the court, please appoint me to serve as my person's agent. But it's not called agent, it's not called power of attorney anymore. Now we are in court appointed guardian land. A guardian is a court appointed office. You have to go through a process with court. You might want to engage an attorney to do this for you. Sometimes there can be a fight about who is going to be the guardian. That can be very stressful and upsetting
Mhm.
for the ones around the person who really needs the help. It's expensive. And it's also an ongoing court relationship. So the court doesn't just appoint someone guardian and they go on their merry way. The court requires reporting every year, there's oversight. And that can be an added burden to a caregiver who's simply trying to get through the day to day of caring for their person.
Mhm.
So that is what happens when there is no power of attorney. Likewise, for financial affairs, if there's no agent designated in a financial power, also called a general durable power of attorney, the families and the loved ones, someone's going to court to get that legal authority, and it can be very burdensome. And it can result in litigation, which is something I would never suggest for anyone.
Mhm.
So, for those people out there caring for someone and they are the agent, they're lucky. Their person has a power of attorney, they've given them that agency under it. How do they know what to do? Number one, read it. Read the power of attorney very closely. If you have any questions about what any of it means, first talk to your person if you're able to, or enlist an attorney to interpret it and guide you as to the scope of your power under that document.
Mhm.
Sometimes some people will contact their local bar association. Sometimes they have pamphlets called "So Now You Are an Agent" under a medical power, or "So Now You're an Agent" under a financial power. Those can be really helpful as well. But sometimes, some people need a little more explanation. And like we mentioned earlier, it's not a good time. You're already doing labor. The person you're caring for maybe isn't so well. That's a lot of burden on one person as the agent. So it's really good to get good, solid advice guiding you. But the paramount principle is when you're an agent, you essentially step into the shoes of your person, and you must always put their interests, the
Mhm.
principal's interests, above your own. The agent serves the principal, not the other way around.
Right. I can see like with families how that could get cloudy sometimes, people with deep emotions and stuff like that. So that's good advice, I think. Um, do you have time for a few more questions?
Yeah,
Okay.
absolutely.
Thank you. Thank you. I really appreciate it. So if we can pivot now to guardianship, and when guardianship is the only option, um, what circumstances is that typically administered or considered necessary?
When you are trying to make decisions for your person and the healthcare professionals will not deal with you because you have no legal authority to do so on their behalf. So that can involve what type of medical care the person is going to receive, your input into that, you're advocating on behalf of your person. You may not be able to see any information because of privacy laws.
Mm-hmm.
So, having a medical power in place will generally allow you access because you're stepping into the shoes of your principal. So, you're entitled to see everything
Mm-hmm.
and be able to make informed decisions that are in the best interest of your principal. Also, you may think that or a hospital might tell you your person needs to be moved to a rehab facility or a nursing home or some other living arrangement, but you may not have the legal authority to do that on behalf of your person because there's no power of attorney in place. That's when people start going to court, sometimes on an emergency basis, to try to get that guardianship. And that can be very stressful and very expensive and can also give rise to conflicts that we really do not need at that time of need.
Right. Um, so a person would only be named a guardian if they didn't have a power of attorney, or is there like another situation where a person would be named a guardian?
So there's a couple of types of guardianship. One we talked about in someone's estate plan, if you have minor kids,
Mm-hmm.
a guardian for those minor children is needed, right? And that guardian is taking care of the kids, on a day-to-day basis, making those educational, social, all those types of decisions for the child, where they're going to school, what they're eating, who's around them, it's basically stepping into the shoes essentially of a parent, but not a parent, a fiduciary. Fiduciaries are a flavor of relationship that an agent under a power of attorney falls under. Fiduciary's obligations are always to the principal.
Mm,
So when you're a guardian for a minor, you're not mom, you're not dad, you are a guardian, which is held to a higher standard, you
mhm,
know. Um, but regarding being a guardian for an adult with a disability or an incapacity over 18, then you are concerned with all of their medical and care and placement decisions, everything about the person, not the money for the
mhm.
most part, but their care decisions. So I think the question was, when does it come into play? Is when there is no power of attorney in place and no one's got the legal authority. Or let's say you are an agent under a power of attorney and the family around you don't like how you're performing, rightly or wrongly. They may sometimes try to get that power of attorney gone, extinguished by a court, and ask the court appoint a guardian.
Okay. It sounds very complex.
Well, it hopefully would
Yeah.
won't be, but there's so many family dynamics. Some people, there are some bad agents who are not doing right by their principals, and absolutely someone might make a report to adult protective services.
Mhm.
Adult protective services might go, open an investigation, delve into what the agent under the power of attorney is doing, and it's not satisfactory, and they might initiate a court proceeding. Mm.
Yeah. It sounds like
To
another reason just to like have everything planned as soon as possible so it doesn't end up in a place like that. And like
Hopefully not.
yeah. Yeah.
I mean, people are always going to do what they do,
Yeah.
but hopefully with education and documents in place and communication is our friend,
Mhm.
from that position of strength. Hey, I'm well, I'm strong now, but my sister, I want you to be my agent in case, anything happens to me while I'm still alive.
Yep.
That way it's known, there's no nasty surprises later. Someone already has their marching orders if and when that ever time comes. Hopefully it won't.
Yeah, for sure. Okay, well, I think that is all the questions that I have for you today. Would you like to share where people could learn more about you and what you do and like website, LinkedIn, anything like that?
Absolutely. I'm on LinkedIn, Stephanie Freeman, Esquire, probate and estate planning and probate. I do a complimentary consultation, a 30-minute complimentary consultation. If you have questions, I can be reached by phone at 720-251-0432. And you can always send me an email at Stephanie at SF, like Stephanie Freeman, SF, ESQ, Esquire, probate.com. So it's Stephanie at SF, ESQ, probate.